So we have a good number of our participants with us. So I think I'll kick off with just some introductions while the rest of our participants are joining us. My name is Stephanie Casey and I'm the manager of the Integrity at Work programme at Transparency International Ireland. And I'm delighted to welcome you all here today. I would just like to remind you that this webinar is being recorded. So if you have to leave us at any stage, it's good to know that the recording will be available to everybody after this session today. So just to give you a little bit of context for this webinar, at the end of 2019, the European Union approved a new directive to protect whistleblowers. Now, Ireland is one of just 10 member states that already has comprehensive whistleblowing legislation in place in the form of the Protected Disclosures Act, which came into place in 2014. The Act will now need to be amended to transpose the directive, and the first step in that process, the General Scheme of the Protected Disclosures Amendment Bill 2021, was launched by Minister Michael McGrath on the 12th of May. So in this webinar today, we're going to take a look at the main provision of the Heads of Bill. We will refer to the General Scheme as the Heads of Bill throughout the session. And we'll explore some of the key issues that need to be explored and considered during the transposition of the directive. So I'm delighted to be joined today by our four speakers, and I'd like to introduce you to them now. I'd like to welcome Ida Nowers, who is the Law and Policy Coordinator at the Whistleblowing International Network. I'd like to welcome Dr. Lauren Kierans, BL, who is Assistant Professor of Law at Maynooth University. I'd also like to welcome Lorraine Heffernan, who is the Managing Solicitor at the Transparency Legal Advice Centre, and John Devitt, who is the Chief Executive of Transparency International Ireland. So in the first part of our session this morning, we will hear contributions from each of our four panellists. Then we'll move on to a general discussion session, and we're going to allow plenty of time for your own feedback and questions. So please send us your questions or your comments using the Q&A button at any stage. If you'd actually prefer to speak to us in person, just raise your hand and we can organise for you to be able to join the webinar and speak to us as opposed to using the Q&A function. So we're aiming to close the session by approximately 10:30. So before we start, I'd just like to kick off with a little poll, which I'm going to share with you now. So let me launch this here. And we'd be really grateful just to hear your response to this question. We'd like you to please rate your awareness of the EU Whistleblowing Directive and or the General Scheme of the Protected Disclosures Amendment Bill. So it's good to know for us as panellists today where you're at in terms of your own knowledge at this stage before we begin our discussions. So just giving a couple of minutes for everybody to vote there. I think we're at about 84% voting. Can everybody see the poll okay? Can I just check that that's visible to you all? Great. Okay, so it looks as if most people have nearly voted at this stage. And it looks like most people are at the somewhat aware level of awareness. So we have approximately 50% of respondents who say that they're somewhat aware, 38% are very aware, and 12% are not aware. So we have a range of levels of knowledge here, but it's good to know that the majority of people are either somewhat aware or very aware. So hopefully most of what we're talking about today will make sense. Okay, so I'm going to now kick off our session by handing over to you, Ida. And what I really like you to talk us through, if you can, is a little bit of the context to the actual directive itself, to the EU Whistleblowing Directive. And it would be really interesting to hear from your perspective, you know, working at WIN and working with partners right through Europe, where other countries are at in terms of their transposition of the directive into their local law.
Thank you very much, Stephanie. My name is Ida Nowers, as has already been said. I'm Law and Policy Coordinator at the Whistleblowing International Network, or WIN, and we are a membership organisation which connects civil society organisations. Our members are all NGOs who are providing direct access to legal advice and practical support for whistleblowers. And we were very much involved with campaigning for the directive, which from a global perspective really is a groundbreaking piece of legislation, in that it introduces some really landmark protection measures. So sort of splitting up the directive into three key areas. It's providing comprehensive protection of whistleblowers. It's establishing a framework of reporting channels inside private and public organisations at the regulatory level and at the EU level. And it's also providing, it's foreseeing, support measures for whistleblowers. And I think it's important to say that for many years, the European Union bodies had maintained there wasn't a legal basis for a directive. So it's really seen as the success of a campaign of a civil society coalition really pushing for reform. And following the LuxLeaks scandal and also the passing of a trade secrets directive, there was more political appetite. It became less justifiable not to protect whistleblowers at the EU level. And so member states, all 27 of them, very different legal systems, must now implement this directive before the 17th of December 2021. And we have been monitoring that process. We have, in collaboration with Transparency International Europe and Eurocad, which is the Trade Union Confederation of Professional and Managerial Staff, been putting together a team of country editors to, on the ground, really monitor the developments in each of those countries. And so if you wouldn't mind, Stephanie, sharing on the screen the EU Whistleblowing Meter. So this is a collaboration between those three organisations, and we are closely following the developments across all of these countries. So this is a publicly available platform. Policymakers, or indeed any member of the public, can log on and look at what their government has done so far. So you can see that we've split it into not started, in progress. And as of yet, you'll see there is not any country which has fully transposed the directive. In February of this year, with Transparency International, we published a progress report which looked at the progress so far across all countries. And only one country, that's the Czech Republic, was considered to have made substantive progress. 2/3, that's 18 at the time, had made little or no progress whatsoever in transposing the directive. And of course, Ireland, with the passing of this heads of bill, now will join Sweden and the Czech Republic in having done more than the others. So Denmark, Latvia, Estonia, the Netherlands, these are all countries which have published either a draft intention of what they foresee the legislation they're going to have to introduce would look like, or indeed they've engaged in some sort of public consultation or stakeholder consultation. And that's really important, of course, with the whistleblowing protection law, because there's quite heavy obligations on business, on competent authorities, to implement these systems. So those involved with those obligations really need to be giving their voice to what that law should look like to make sure that it works in practice, because we know that Although the directive is very good, it's very strong, it does have weak points. There's still loopholes. And if this system doesn't work in one area, then trust and confidence in the whole system can be undermined. So our work to share expertise and argumentation to push for more progressive provisions on the national level continues, because the directive very much only produces or requires minimum standards. And actually the Commission has repeatedly encouraged member states to go further than those minimum standards, because the aim here is a comprehensive and coherent framework across Europe. And of course, we've seen member states take either a minimal approach, where they're verbatim transposing that directive, or indeed going further. So one of the key issues there is material scope. Less of an issue in Ireland, because of course you already have a comprehensive whistleblowing law, and indeed the directive has a non-regression clause. So no EU government can introduce measures which are less than the protection that's already within the country. But the EU Commission, or the lawmaking bodies, can only make law based on EU competency matters. So the directive talks about breaches of union law, but of course it's a nonsense if a national law protects those reporting breaches of union law and not even serious breaches of their own national criminal law. So again, these arguments are brewing across Europe to make sure that this minimal approach, which we see proposed in the Netherlands and in some other member states, isn't allowed to proceed. There are other issues that we've been able to pick up as a team across Europe in terms of loopholes in the law. We've got a number of briefings on our website that I will share in the chat, which are picking up these policy areas. And I'm happy to answer any questions when we have a discussion later. Just final note to say that all member states of the European Union are, of course, member states of the Council of Europe. And there have been resolutions and recommendations which discuss the directive's provisions and talks about where really member states can go that bit further. And again, I'll put some of the reports from the Parliamentary Assembly of the Council of Europe in the chat as well. So really, we're quite delayed across the board, and you know, it's yet to be seen whether any country will meet the deadline. So it's good to see Ireland has gone further so far, and really interested to hear the discussion about those provisions.
So thanks a million, Ida. That was a really useful overview. And as you said, thanks a million for, it would be great if you could share links to those resources, and we will share all of those with you in the chat as well later on in the session. So before I turn to Lauren to bring us through some of the main changes that are proposed in the Heads of Bill, I'm just going to actually launch a second little question to you all here. So I hope you can all see that now. So again, the question here is, how confident are you that your organization or your employer is prepared to deal with protected disclosures effectively? Okay, so we're having, again, quite positive results coming up so far. I'll share the results with you in just a second. Had about 84% of people voting so far. And it's really good for us actually just to hear. It's really useful for us in Transparency International Ireland as well to get a sense of, you know, where organisations are at as we speak at this very pivotal time, as Ida was saying, you know, for the introduction of these new additional changes to our protected disclosures legislation. And good to hear as well, Ida, that Ireland is slightly ahead of the curve in relation to other countries as well. So hopefully we will meet that deadline of December 17th for complete transposition. Okay, so I'm going to end this poll just now, and let me share the results with you. So in response to this question around confidence that your organization or employer is prepared to deal with protected disclosures effectively, 47% of respondents said they were very, very confident. 44% said they were somewhat confident, and 9% said that they were not confident. So again, a good degree of confidence coming across in these results, and a good degree of knowledge in this area coming across, which speaks to the audience that we have with us today. So that is very interesting as we turn to Lauren. So Lauren, I'd be really grateful if you could take us through just an overview of some of the main changes that are proposed in the heads of bill. And I think you're going to share a presentation. Thanks a million.
Great. Thank you. Sorry. Sorry, the bar is in the way of the, to put on the, sorry, slideshow. Apologies. Great. Thank you very much, Stephanie, and thank you kindly to Transparency Ireland for the invitation to speak today on the general scheme of the Protected Disclosures Amendment Bill 2021. So this, which I'm going to call the Heads of Bill, was only published 2 weeks ago. It was published on the 12th of May 2021. And as Stephanie has already alluded to, the purpose of the Heads of Bill is to transpose the EU Whistleblowers Directive into national law. So Ireland's main whistleblowing legislation is the Protected Disclosures Act 2014. And that has been in place in Ireland for nearly 7 years. So it was enacted on the 15th of July 2014. So we are very excited to see that the legislation is going to be amended, and are optimistic that it's going to bring in improvements for not only the whistleblower, but also the organisation, from the perspective that there will now be obligations to deal with the alleged wrongdoing. So under the Protected Disclosures Act 2014, that in many ways is considered a reactive piece of legislation, in that it provides protection to workers after they've made a protected disclosure and who allege that they suffered retaliation for having done so. So now with the EU Whistleblowers Directive, we're going to see some fundamental changes to the Act, and many of these are going to relate to the obligation to deal with the disclosure itself. So the heads of bill, we have 26 heads in the heads of bill, and they are contained in 6 different sections. So for the purposes of today's presentation, I'm going to bring you through 5 key provisions. Now, both John and Lorraine will be discussing in more detail some nuances as regards the heads of bill, but I'm going to give you a general overview of some of the provisions that we can expect to be transposed once the deadline has been met. So the directive will have to be transposed by the 17th of December this year. So first and foremost, I'm going to discuss Head 7, and that relates to the personal scope under the Protected Disclosures Act. So currently, under the legislation, the protections are provided to workers, and we have quite a broad definition of worker already. It is undoubtedly one of the most comprehensive under labour law statute in Ireland. So we're talking about protection not only for employees, but also former employees, temporary employees, contractors, consultants, agency staff, members of the Defence Forces, and certain interns and trainees. Now, on foot of the transposition of the directive, we will see an expansion covering a further range of individuals who can make protected disclosures. So Head 7 of the Heads of Bill proposes to extend the definition of worker under Section 3 of the Act to cover shareholders, members of administrative management or supervisory bodies of an undertaking, including non-executive members, further volunteers and unpaid trainees, and also those who acquire information on a relevant wrongdoing during a recruitment process or other pre-contractual process. Now, the extension of worker, as we know, will cover these further range of individuals. However, depending on whether they're included in the definition of employee or not, they will have different forms of remedies available to them on transposition of the directive, and I will address that when we get to the issue of retaliation. Now, as regards internal reporting channels, this is something that many organisations here today may be having concern about, because we're going to see some stringent obligations imposed on organisations in respect of establishing internal channels for receiving and handling protected disclosures. So currently under the Protected Disclosures Act, only public bodies are obliged to establish and maintain protected disclosures procedures for their own employees. So Section 21 is going to be repealed, and we'll see an amendment to Section 6 of the Act, which deals with disclosures to employers. So the obligation that is proposed in the Heads of Bill, following on from the provisions in the directive, is that all employers with 50 or more employees will have to establish and maintain internal channels and procedures for both the making of protected disclosures and the following up of protected disclosures. Now, this can be extended further for channels to be put in place for disclosures to be received from workers other than employees. Now, as regards the public sector, there will be no threshold for the establishment of the internal reporting channels. So the requirement for the private sector of there being 50 or more employees doesn't apply to, or will not apply to, the public sector. And that is in line with the obligation for Ireland not to include regressive clauses in the legislation. So as it currently applies to all public bodies, that will be retained. However, there will also be no threshold for organisations who are in the area of financial services, financial products and markets, prevention of money laundering and terrorist financing, transport and protection of the environment. Now, as regards employers who have between 50 and 249 employees, this obligation to establish internal reporting channels will not come into force until the 21st of December 2023. So there is an opportunity to avail of a longer period of time to implement these channels. Now, as regards the obligations for establishing channels for the making of protected disclosures, there is also, as I said, this obligation to have information regarding the following up of protected disclosures. And that is key as regards dealing with the disclosure itself, which the Protected Disclosures Act is currently silent on. So as regards following up, this is not an obligation to investigate every protected disclosure. What it means is that the organisation will have to assess the accuracy of the information and, if relevant, carry out an internal inquiry, an investigation, or even decide to close the procedure. So this will be really the key to having, I suppose, internal channels for dealing with the protected disclosure. Now, there are also specific requirements that will have to be included in those procedures for organisations in the public and private sector. So you will have to acknowledge receipt of disclosures within 7 days of having received it. You will also have to designate an impartial person or persons competent for specific issues. But this can be referred to an external third party. And that external third party will also have the obligations that would be imposed on the impartial person or persons internally in the organisation. So, for example, the impartial person will have to maintain communication with the reporting person. They will have to ask for further information where necessary. They will have to provide feedback. And that will have to be done within a reasonable time frame, up to a maximum of 3 months of the date that the protected disclosures receipt was acknowledged, or if there was no acknowledgement, within 7 days from the expiry after the report, the 7-day period after the report was made. Now, there will also have to be diligent follow-up. And further, the reporting person will have to cooperate with any follow-up or investigation. So this impartial person, may also be the same person who's designated to receive the protected disclosures. And further, there will have to be provision of clear and easily accessible information regarding the making of internal and external disclosures. And those disclosures will have to be permitted both in writing and orally. And if it's made orally, it must be permitted to be made via telephone, other voice messaging system, or if requested by the reporting person within a reasonable time, they should be permitted to a physical meeting. Now, as regards the external reporting channels, this is dealt with under Head 10. And under the EU Whistleblowers Directive, there is an obligation for all member states to designate competent authorities to deal with protected disclosures. In Ireland, we already have such a system under Section 7 of the Protected Disclosures Act, which provides for disclosures to be made to prescribed persons. There are currently 110 prescribed persons, and this, under the Protected Disclosures Act, is considered a second step disclosure, whereby the worker must meet additional criteria in order to be afforded the protections under the Act. However, with the transposition of the EU directive, those additional criteria will be removed, and the same conditions for an internal protected disclosure will apply to a disclosure to a prescribed person. Now, as regards prescribed persons, they will have to have independent and autonomous reporting channels for receiving and handling protected disclosures. The same obligations apply as regards internal disclosures, in that the disclosure must be, receipt of the disclosure must be acknowledged within 7 days, a maximum of 7 days, unless the reporting person explicitly requests for it not to be acknowledged, or the competent authority, that is the prescribed person, feels that such acknowledgement would jeopardise the protection of identity of the reporting person. They must diligently follow up on the reports unless they deem that the report is clearly minor, although there is no indication as regards what is deemed to be minor, so that will be left to each prescribed person. Also, if it's a repetitive report, if it contains no new meaningful information, they may close the procedure. Or if they are not the appropriate prescribed person, so they don't have the relevant competence to deal with the disclosure, they must transmit it to another prescribed person. Further, if it is a very serious wrongdoing, they may deal with it as a matter of priority over other protected disclosures. They have to provide feedback within 3 months, or a maximum of 3 months, or 6 months in duly justified cases. Again, however, it remains to be seen as what is a duly justified case. They must communicate the final outcome to the reporting person. They must also have trained members of staff who are designated to handle protected disclosures. And further, they must publish information in a separate, easily identifiable and accessible section of the website. And this is key. Research that I conducted in March of this year found that of the prescribed persons, 68% had no information publicly available as regards their role, and 32% did have information publicly available. So this will become a statutory obligation now to have that information publicly available on their websites. Now, one key change to the Protected Disclosures Act is the introduction of the Protected Disclosures Office, and this will be discussed in more detail during the panel discussion. But the heads of bill in head 16 to 20 deal with the establishment and functions and powers of this office. The Protected Disclosures Office, so the PDO, will be a prescribed person for the purposes of the 2014 Act. And their main functions is, if they receive a protected disclosure, to transmit it within 7 days to the relevant prescribed person who's competent to deal with the wrongdoing or the alleged wrongdoing, or to another suitable authority. If there is no prescribed person or suitable authority, the Protected Disclosures Office will have to follow up diligently on the disclosure itself. Further, it's going to have a very important role in respect of disclosures received by ministers under the Act. So currently under Section 8 of the Protected Disclosures Act, a public sector worker can make a disclosure to a minister who has a function in respect of that public body in order for it to be considered an internal disclosure. But it can also receive disclosures externally, but it is deemed a wider public disclosure and attracts for more stringent conditions for its protection. However, if a disclosure is now made to a minister under Section 8, that will then be referred within 7 days to the Protected Disclosures Office. And that Protected Disclosures Office will then be the primary point of contact with the reporting person, and will maintain communication, ask for further information, and provide feedback to that reporting person. Further, they will have to refer the disclosure to the relevant authority who's competent to deal with the disclosure. And if there is no suitable authority, they will deal with the disclosure itself and diligently follow up. Now, finally, in respect of protection from retaliation, there is now the extension to protection from penalization to the new forms of reporting persons under the Act, except for shareholders. So members of the administrative management or supervisory authority body undertaking, including non-executive members, volunteers, and those acquiring information in the pre-contractual process and recruitment process and so on, they will have to bring claims for penalisation against their employers before the Workplace Relations Commission, whilst shareholders and other workers have to bring their disclosures before the civil courts for detriment. Now, the cap on compensation under the heads of bill is for a maximum of €13,000 to be awarded to such employees or such work, these will fall within the definition of employee, if they suffer penalisation and they're not in receipt of any compensation, any remuneration. Further, under the Protected Disclosures Act currently, employees who have been dismissed for having made a protected disclosure can bring a claim before the circuit court to be either reinstated, re-engaged, or to have their contract of employment continued until the substantive hearing of their unfair dismissal claim. This will now be extended to provide interim relief applications, or the right to bring an interim relief application before the circuit court by employees who allege they've suffered penalisation for having made a protected disclosure. So that is very much just an overview of the key heads of bill. We will be discussing these in more detail in the discussion with Lorraine and John, and further in the panel discussion. So as we can see, there is a lot happening as regards the changes to the Protected Disclosures Act, but no doubt the heads of bill will require much more pre-legislative scrutiny, particularly because the Act is still silent on certain issues. So, for example, in respect of penalties, the disclosure of trade secrets, it does address it in respect of prescribed persons, but otherwise it is silent. So we are, I suppose, anticipating more changes when we finally see the bill in its published form. So thank you very much. I'll stop my share now, Stephanie.
Thanks a million, Lauren, and that's what an incredibly in-depth overview. Thank you so much. And as you said, this is really just the start of the process. You know, we see this event today as the beginning of a series of events that we'll host, and indeed we could probably take just one head that you've outlined there, Lauren, and go into it in in-depth detail if there's a requirement for that. And you know, we really will welcome people's comments and feedback as to the kinds of events that we do going forward as the transposition takes place. Lauren, quite a few questions have come in there as you were speaking, but I think what we'll do is continue with the with our panel contributions, and then we'll move to take all of the questions and have a general discussion, and we'll leave plenty of time for that. So I'd like to turn now to Lorraine, Managing Solicitor of the Transparency Legal Advice Centre. Lorraine, would you share some of your observations and thoughts on the heads of bill and some of the key points that you'd like to highlight?
Yes, thank you, Stephanie, and good morning, everyone, and thanks for having me today. So yes, as a lawyer advising disclosures, it goes without saying that I welcome the enhanced framework that this new directive offers, and I was delighted to read the general scheme published on the 12th of May last. So at the outset, I'll just echo the point already made that we're at a very early stage in this process, but nevertheless, it is important that we do start to consider things carefully now, so that by the end, we do end up with a framework that works both for the discloser and the receiver of the disclosure. It will only be when all stakeholders have a clear understanding of the framework and their rights and obligations under the law that we can aspire to running a system that's fair to everybody. So this morning, I've been asked to pick 3 points of interest from the recently published general scheme and to present them to you. So there are many to choose from, and so the 3 that I've chose to briefly mention are, firstly, the proposed insertion of a new subsection 9 at section 5 of the Protected Disclosures Act that strives to exclude a certain type of grievance from the remit of the Act. The second item I'm going to mention is the new protections and references to the rights of persons concerned in the scheme and directive. And the third item I've chosen are the new additions that are proposed in relation to information gathering. And there are new obligations in the general scheme on reporting persons to cooperate with internal and external investigations. And also the new power of the director of the new Protected Disclosures Office to, in writing, request information from persons or request the attendance of a person to give information to the director in person. So just before I begin, as they say, old habits die hard. So where I mention a PD, if I do that, I'm talking about a protected disclosure. And if I refer to the PDA, I'm referring to the Protected Disclosures Act. So firstly, turning to head 5 and the new subsection 9, which is being inserted into section 5 of the Protected Disclosures Act. This states, A matter is not a relevant wrongdoing if it is a matter concerning interpersonal grievances exclusively affecting the reporting person, namely grievances about interpersonal conflicts between the reporting person and another worker, and the matter can be channeled to other procedures designed to address such matters. So as things stand, we have a number of elements in the current legal framework that have often been referred to as excluding grievances from the protected disclosure framework. So firstly, section 5.3b of the Protected Disclosures Act that states inter alia that it is a relevant wrongdoing if a person has failed, is failing, or is likely to fail to comply with any legal obligation other than one arising under the worker's contract of employment. And secondly, the Code of Practice on Protected Disclosures contained in SI 464 of 2015, which at sections 30 and 31 expressly sets out what a grievance is, and at 42 refers to grievances as being concerns that may not form the basis of a protected disclosure. And thirdly, the guidance issued by the Minister under section 21 of the PDA at 13 makes distinctions between complaints and protected disclosures. So why do we have this proposal to insert the quoted new 5.9 into the Protected Disclosures Act? I think this is something to think about. So the inspiration for this section, it does not come from the operative provisions or main articles of the directive, but rather from recital 22 that introduces the directive. And for anyone who isn't a lawyer here, recitals appear at the beginning of an EU Act, and they set out the reasons for a directive's operative provisions. Recitals to EU laws are not in themselves legally binding in the same way that the operative provisions are, but they do assist with the interpretation of a directive. So in this instance, recital 22 states that member states could decide to provide such a provision in relation to interpersonal grievances. So this is not a provision that we must include. So therefore, perhaps we need to think about what might be the pros and cons of introducing such a provision. And I think anyone dealing with protected disclosures will know that grievances and protected disclosures do often come up together. So at first glance, one might think that the use of the words interpersonal and exclusively affecting the reporting person and describing the issue as being one that lies between the discloser and another worker, as well as meeting the condition that the matter can be channeled to other procedures, would be a good way to define a sort of grievance that should not be protected as a disclosure of wrongdoing. You can see, however, already that there are a lot of parameters to be met to fit the exclusion of this sort of grievance. And one might argue that 4 parameters leaves a lot of room for argument. And it is true that often when there is a lot of room for argument, this is not helpful. Of course, not all grievances are interpersonal, so this provision refers to only one sort of grievance. The insertion of this provision, no doubt, is intended to be helpful. However, this attempt does also highlight and perhaps acknowledge that there is a difficulty faced by both employers and disclosers in understanding that while a grievance in its truest sense would not fall within the remit of the PDA, it is not the case that a grievance may not contain protected disclosure elements. As we know, life does not happen inside neatly defined parameters, and the employment arena is a human relationships arena as well as a business one. So to highlight how the reality of life on the ground intersects with the law in this arena, I'm going to quickly cite 2 recent High Court cases that might give us some pause for thought on this issue. So the first case is Baranya and Rostera Meats Group Limited, a decision of the High Court in 2020 of Justice Miriam O'Regan. So paragraph 21, and I'm paraphrasing here, the court indicated that it was of the opinion that in relation to protected disclosures, there was an effective spectrum. On one end, you have a grievance, and on the other end of the spectrum, a protected disclosure. And Justice Regan stated, and I'm quoting now, between these 2 extremes, there was the possibility that a protected disclosure and a grievance would overlap. I think this remark does highlight the point that I'm making, and it's perhaps something that we need to keep to the forefront of our minds when thinking about the proposed new provisions. There are also a lot of interesting comments in the case of John Clark and CGI Food Services Limited and CGI Holding Limited. And this was another decision of the High Court, a decision of Mr. Justice Richard Humphreys on the 31st of July 20. So to say this case did not centre on grievances. However, Judge Humphreys made some cogent remarks on the reality of the situation a discloser may find themselves in. And I think it's worthwhile reflecting on this, on the sort of situation someone dealing with a disclosure is often immersed in. So at paragraph 16, Judge Humphreys stated, the breakdown of an employment relationship, like that of any relationship, is not necessarily a linear process with entirely logical and rational steps on all sides. There can be vacillation, mixed feelings, false dawns, reconciliations and setbacks. And sometimes it is only after the person picks themselves up off the ground, even if even then, that they start to figure out what actually happened. So indeed, it is often the case that a discloser is the sort of worker who has had the rug pulled out from under their feet. Often they are loyal employees who expected more from their employer and most definitely did not expect to be at the receiving end of adverse treatment. This has the effect of blindsiding the worker, who has then got to get their head around what is happening in the workplace, and on top of that, an unexpected employer's reaction. Often such a worker does not know where to begin. The worker is not a lawyer. So you can see that it is understandable, and we can anticipate that matters may initially be reported as grievances. It's hard to speak up. It's hard to put everything on the line. It's not just the worker. It is their family, their children, their place in the community, in parishes, clubs, and everywhere they go. Speaking up really does go to the heart of a person's existence. Also, it can be hard for the employer to hear of the disclosure. No one likes the finger pointed at them. And a situation can quickly arise where everyone feels threatened and focus is drawn to all quarters, relevant and irrelevant. The remarks such as those of Judge Humphreys are very important to reflect on, as they anchor us back to the reality of the situation a discloser is immersed in. A discloser is extremely vulnerable. A worker speaking up and putting themselves on the line for the sake of a greater good most definitely deserves the fullest protection we can offer. Indeed, I would say that I've met some very extraordinary people with the highest integrity in my work, and it is painful to see what they go through, and indeed it is unjust. So connected to this reality is that while a discloser may not know legally where to begin, that once a disclosure is made, that this is the point of importance and not within what process it was made or what title was given to the disclosure by the worker or the employer. And in this regard, I'll quote from Judge Humphreys again at paragraph 17 when he said, one can make a protected disclosure without invoking the 2014 Act or without using the language of a protected disclosure. So these two decisions importantly reflect the nuances involved in both the making of and the receiving of a disclosure. Disclosure recipients will not all be lawyers, so perhaps now an opportunity exists to give clarity to all stakeholders and state clearly that it is not the case that any grievance can be dismissed out of hand as definitely not also comprising a protected disclosure element. These are the realities of how life plays out. As I said, the employment relationship is a human relationship, and the legal framework, if it attempts to distinguish certain sorts of grievances as excluded, should also reflect that a grievance may contain protected disclosure elements, and also acknowledge that a discloser may not even realise themselves the implications of what they initially think is merely a grievance until after the event. If we don't do this, grievances that do encompass protected disclosure elements could fail to be detected or even willfully ignored. So there ends my food for thought on the new section 5.9. I'm going to move now to the second item that I've chosen to mention, and this is the new protections and references to the rights of persons concerned in the scheme and directive. So as we know, a disclosure does not only involve the disclosers themselves, but also those that are implicated in the wrongdoing. Head 2 of the scheme defines persons concerned, as meaning a natural or legal person who is referred to in a protected disclosure as a person to whom the relevant wrongdoing is attributed or with whom that person is associated. Needless to say, a person to whom wrongdoing is attributed is going to need to be protected. Under the current regime, such a person was relying on their natural justice and fair procedure rights and not directly on the provisions of the Protected Disclosures Act for protection. So in this regard, express references to the rights of persons concerned in the new legislation will provide welcome certainty and reassurance to such persons that their rights will be protected and they too will be offered protection in the face of allegations. These are rights that we as persons dealing with protected disclosures need to be very careful of. So what does the new legislation say? Well, at head 13, this deals with the duty of confidentiality, which amends section 16 of the Protected Disclosures Act. So this head, amongst other things, inserts a new 16b into the Protected Disclosures Act that states the protections that apply in respect of section 16 shall also apply to persons concerned. So what this means is that persons concerned, their identity must be protected. Also, if their identity is to be disclosed to another person in accordance with 16.2 of the Act, for example, for the effective investigation of the wrongdoing, the persons concerned must be informed before their identity is disclosed, unless such information would jeopardize the related investigations or judicial proceedings. And then, as we know, if the protections of section 16 are to fully apply, in 16.3, it makes failure to comply with the obligation not to disclose a person's identity actionable if that person suffers any loss by reason of the failure to comply. So further reference to the requirement to protect the identity of persons concerned is made in head 17, that refers to the power of the Director of the Protected Disclosures Office as a prescribed person. And the Director has the power to refer a disclosure to any other person who, in the opinion of the Director, is an appropriate recipient once a number of conditions are met. And one of those conditions is that the recipient must be able to protect the identity of the discloser and the persons concerned in accordance with section 16. And a similar provision then is in head 18 in relation to the role of the Protected Disclosures Office and disclosures made to a minister of the government or a minister of state. And again, this can only be referred to somebody chosen by the Director once this person can protect the identity of the discloser and the persons concerned. So then the next reference in the scheme is at head 23, which is headed Protections for Persons Concerned. And this inserts a new express provision that none of the provisions in the Act shall impact the rights of persons concerned under the Charter of Fundamental Rights of the European Union. So that's the wording that's in there now, and I know it is very early days, but maybe I could ask, does anyone know what those rights are? You know, such a provision is welcome, and it seeks to transpose Article 22.1 of the directive. However, Article 22 expressly refers to what these rights are, including the right to an effective remedy and to a fair trial, as well as the presumption of innocence and the rights of defence, including the right to be heard and the right to access their file. Given the importance of these rights and the opportunity that exists now to offer clarity and certainty, perhaps naming these rights in the new legislation could also assist all stakeholders involved, and particularly disclosure recipients who need to be mindful of persons' rights and know what they are. And of course, also the persons of concern themselves, they need to know what their rights are. I know that when I read the rights set out in Article 22, I felt this was very heartening and clear, particularly as often fair procedure rights can seem a little elusive to non-lawyers as to what exactly they are. And indeed, the case law shows that perhaps at times they are elusive to lawyers as well. So to conclude on this point, we can see that the new law will provide increased protections to persons of concern vis-a-vis protection of their identity. And we need to be mindful of this aspect when dealing with disclosures. And as always, we must continue to be mindful that persons of concern have rights too. So now I will quickly move on to the third item that I've chosen to refer to, and these are the new additions that are proposed in relation to information gathering. In the scheme, there are new obligations on reporting persons to cooperate with internal and external investigations, and also the new power of the Director of the new Protected Disclosures Office to in writing request information from persons or request the attendance of a person to give information to the Director in person. So Head 9 inserts amendments to Section 6 of the Protected Disclosures Act. So a new Section 611 is proposed that states, the reporting person shall cooperate where required with any investigation or any other follow-up procedure initiated in accordance with Section 6(9)(d), and this refers to cooperating with internal investigations. The language you see is quite strong. They shall cooperate. Similarly, there is a provision at Head 10 that relates to external reporting channels, and this amends Section 7 of the Protected Disclosures Act with a new 7(5) that states, the reporting person shall cooperate as required with any investigation or other follow-up procedure initiated in accordance with Section 4C. Again, this relates to an obligation to cooperate with external investigations. The language of these sections stands in contrast to recital 57 of the directive, and this gives pause for thought, because at recital 57 it states, it should be possible to ask the reporting person for further information in the course of the investigation, albeit without there being an obligation to provide such information. Reading the recital in conjunction with these two proposed amendments, it's clear that the use of the wording shall cooperate does not accord with there being no obligation to provide such information. Saying that in the absence of any sanction, it's difficult to see how a discloser could be forced to cooperate, and indeed if matters were of a serious nature, a discloser's right not to self-incriminate would also come into play. But it's important, I think, that we consider all matters in the context of enhancing the disclosure framework that we have. And indeed, it's not my usual experience that a discloser withholds information or does not cooperate with an investigation. But my more usual experience is that they eagerly hope for and wait for an investigation to be instigated. And then often at the end of that process, they have to work very hard if they want to discover what the results of those investigations were. It's also important to remember that the balance of power in these matters is not with the discloser, who is often oppressed and frightened. Further, a common experience of disclosures in the workplace is that multiple investigations are instigated against them, such as for breach of confidentiality, multiple performance meetings, and such like. There is the risk that this new element in the framework could distort the balance of power even further, giving perhaps an unscrupulous employer the opportunity to wield yet more power over an already overburdened discloser. Indeed, an example of how an unscrupulous employer might behave, I refer again to the earlier Clark decision, where an employer bombarded a worker's email account with 1,746 emails in one day. And while this was not necessarily connected to information gathering, it gives us an idea of the potential for abuse that such a provision might provide. While this is an extreme example, we should pause for thought and consider the distinction between receiving a large volume of emails per se and receiving a large volume of emails to which you are legally obliged to respond. So in contrast to that, the final reference to information gathering that I'm going to mention relates to persons as opposed to the reporting person. And this is to be found at Head 20, and it relates to the powers of the Protected Disclosures Office. So this head gives the Director at 2 all such powers as are necessary to the performance of his or her functions under this head. And in particular, the Director may, in writing, request a person to provide him or her with such information as he or she considers necessary for the performance of those functions. Request the attendance of a person or persons to provide information to the Director in person. I'll just note here that there is no shall cooperate requirement. And so the sentiment of this section seems more in line with what is envisaged by Recital 57 in relation to reporting persons. And that is, it should be possible to ask for the information without the obligation to provide it. So that brings me to a close of my 3 observations. So I will conclude by just mentioning that these are only 3 points from a new and ambitious framework, and I present them as food for thought. No doubt there will be many roundtables to go before we finally get to grips with the scheme and the new legislation as it comes along. It goes without saying that it's really important for everyone that we end up with a framework that works better both for the discloser and the receiver of the disclosure, and one that enables all stakeholders to have a clear understanding of their rights and obligations under the law. And finally, I congratulate DEPA on producing their work. It is a large and complex task, and a tremendous amount of work has gone into it, so well done. And there ends my 3 observations, and thank you very much for your attention, and I'll hand you back to Stephanie.
Thanks a million, Lorraine, and food for thought indeed. Lots of food for thought there. Now we have a flurry of questions and comments coming in. I know Mary Flynn would like to make a point as well. Mary, I see your hand up there. So what I'm going to do is I'm going to actually hand over to John now. John, I know you would like just to share your own observations and some of the key points to consider in terms of the transposition. I'm going to then perhaps suggest that we go directly onto questions rather than to our general panel discussion, because I am conscious we've had so many questions through, and I'd like to devote the end of our session to that. And sorry, I see Aileen Fleming also has her hand up. So John, I'll hand over to you now, and then we shall go straight to the questions from the attendees. Thanks a million, John.
Thanks, Stephanie. Thanks, everyone. There's a lot in there already, so I'll try and keep my own contribution relatively short, but I thought it would be worth highlighting 1 or 2 points, notwithstanding the fact that we've welcomed the publication of the heads of the bill. We're very happy with the approach taken by the government at council level during the negotiations around the directive itself. Been assured and happy to see that a horizontal approach, or that the directive should be implemented or transposed horizontally, meaning that there should be no distinction made between the protections enjoyed by workers in reporting national or EU law. But I imagine that there will be some features or some provisions which will present some challenges more than others, and 2 or 3 came to mind when reading the heads. And people will be familiar with Article 25.2 of the directive, which is a non-regression clause, making it clear that the implementation of the directive under no circumstances will provide for grounds for reduction in the level of existing protections. And the Protected Disclosures Act itself is a fairly robust and comprehensive piece of legislation. There are weaknesses which we've highlighted in the past, but workers here enjoy protections that their counterparts elsewhere in the EU don't have in many, if not most, cases. Currently, the Act allows for public service workers to report directly to a minister, and we understand, having talked to departments and engaged with officials in those departments, that this has presented a particular challenge when acting on them and in determining whether they have the competence to act on them, where the disclosure being made by a worker who is not directly employed by the department, so an agency under the department's aegis, ought in theory, to be able to handle those disclosures themselves. But there will be circumstances where the disclosure needs to be considered by, or action needs to be considered by, the department. And the heads are cognizant of the fact, or seem to be cognizant of the fact, that there have been challenges in implementing Section 8 of the PDA. But Head 11 will create new tests for workers, or it's suggested that they will create new tests for workers in reporting to a government department, to a minister. And it will provide for a test requiring a worker to show that they've previously made a disclosure of substantially the same information in the manner required in Section 6 or Section 7. And it'll require them to report to their, essentially to their own employer or to a prescribed person, now, before reporting to a minister. Now, workers currently have a right to report to the minister, and in removing that right, or in adding additional tests, it may not be compliant with Article 25.2, and this is something I'm sure that the AG's office and the department will be very mindful of, but it's something for us to consider in light of Article 25, and consider also how we can build the capacity of government departments to assess and to receive and assess those concerns. There's already a framework in place that supports government departments, the Office of Government Procurement framework, which allows departments to procure the services of assessors and investigators. And the heads will also create a protected disclosures, or the act, a new act will create a new protected disclosures office, which should offer additional support to government departments in assessing and investigating. I wouldn't advocate one approach over another, but there should be multiple avenues through which workers are able to raise concerns, and it's important that they continue to be able to make a report to a minister. I think it's also worth highlighting Head 8, which relates to anonymous disclosures, and we understand that there's no requirements on employers to act on and follow up on anonymous disclosures. But one of the beauties of the Act as it currently is written is that it's silent on anonymous disclosures. It should be assumed or presumed that where an anonymous disclosure is made in a manner consistent with the Act, that the protections and the current protections available to those making confidential disclosures will be afforded to those making anonymous disclosures. In other words, the protections afforded to people who don't share their identity should also be made available to those who do in confidence. Now, the argument will be made, well, how can we protect people whose identity we don't know? We would argue that where their identity does become known, that they should be able to avail of the same protections as those of confidential reporters. And it should also be incumbent on employers to act on information where it can be determined that a wrongdoing, a relevant wrongdoing is taking place or is likely to take place, irrespective of whether they know the identity of a disclosure. It's important also that they have the resources to be able to act on those concerns, and that they have the policies and procedures to act on them thoroughly and promptly. Which brings me to my final point, which is that the provisions under Head 8 requiring all employers with more than 50 staff, and those designated by the minister or others in financial services and other sectors highlighted in the provided for in the directive, that should also be extended to all employers in the same way that the Safety, Health and Welfare at Work Act requires all employers, irrespective of the size, to have policies and procedures in place to address health and safety risks. There is already a model whistleblowing policy under the Code of Practice. There are so many free resources available to employers now to be able to put in place policies and procedures that I think we should seize the opportunity we have right now to make the legislation as strong as possible. And one way we can do that is by extending the requirement on all employers to have policies and procedures in place. I'll stop there because I know we have only about 15 minutes or so for questions, but I could go on. And by the way, we do have our submission on this, which I'll share the link to in the chat, which will give you more on we'll share. I'll share the submission. It'll give you an overview of where we think or how we think that the directives should be transposed.
Great, John, thanks a million. And just to clarify, we will be able to email you a copy of Lauren's presentation, and we can also share a link to the recording of this webinar to you all. And we will also email you useful links which have been shared by John and by Ida and Lauren as we've gone through the morning. Okay, so people have asked questions and I think we should get going on those. We have a number of questions in the Q&A and actually also a number of questions in the chat. So I'm actually going to start in the Q&A button. I think you can all probably see the questions that are in there. I'm actually going to kind of start from the bottom up so we can try, because some of the questions towards the bottom end of the Q&A box are probably more quickly answered than some at the top, and then we move into the chat questions as well. So the first question here that I'd like to just take at the very bottom of the Q&A box is around the more than 50 threshold. And the question is that more than sorry, because the reason I'm pausing here is a little box has appeared in front of what I was reading. Okay, so is more than 50 employees, or is that more than 50 employees or more than 50 full-time equivalent workers? I'm thinking of a situation where an institution may have contract workers that bring it to over 50. So does anybody have some clarity on that particular question? So is it 50 employees or 50 full-time equivalent employees? Maybe we don't have an answer to that question.
It's not clear. It is employees. And that would, I suppose, fall with under what is the definition of an employee in the Act. It does provide that it can be made available for other workers, which I would think contractors would fall under that. So currently it is just specifically for, this is regards the internal reporting channels. It would have to be the employee as per the definition under the Act, would be my understanding. So contractors don't fall within that definition. It falls outside into the definition of worker, and it remains to be seen that the heads of bill give power to make it available for other workers, but it isn't made clear at the moment whether that will actually be an obligation. It seems to give them the option.
Okay, very good. And so, and then just, I suppose, building on that, so that there probably needs to be some more clarity around whether it's actually FTE employees or any kind of employee.
Yeah.
I'm sorry if I can
yeah.
add there. I mean, we could avoid all this confusion to begin with by extending the requirement on all employers, irrespective of the number of staff they have. This is going to cause enormous confusion, I'm sure, and that discriminatory approach will leave some employers, you know, at some point you understand that you won't always have, you'll be on the borderline as a medium-sized enterprise. You might have 48 employees one year, 50 employees the next year. You may have 40 employees the year afterwards. Does that now leave you without any obligation to have policies and procedures in place? I think this would just be much easily. It'd be much better to handle this by extending the requirement on all employers.
And there is the power for member states to do that, to get rid of the threshold, and they just have to inform the European Commission of that.
Yeah.
Yes, and actually Kate Kenny has just commented there that she agrees with that point, John. Approximately 50% of employees in the private sector work in firms with less than 50 employees. And, you know, Ireland has a strong SME micro enterprise presence, so it would be very important to extend to similar firms. And I have to say, I think also the charity sector needs to be considered there, because we've seen so many issues in the charity sector and so many charities of less than 50 people. So it is certainly something that, that probably should be considered. I'm going back into the Q&A. Fanula McGee has asked, welcoming the codifying of rights of persons concerned, will this affect the current provisions of the COP re anonymous disclosures? And actually, just on that question of the rights of persons concerned, there was a question around, what do we mean by the persons concerned? Is that the respondent or the subject of the disclosure? So Lorraine, I might just come back to you on that. And sorry, just to not be using acronyms and COV being the code of practice in this question. So will this affect the current provisions of the code of practice regarding anonymous disclosures? Lorraine, I'll come back to you on this one.
Okay. So, well, just first of all, to say persons concerned, are those implicated in the wrongdoing, or are those associated with persons implicated in the wrongdoing? And that's very clearly set out, the definition of what persons concerned are. Then in relation to the code of practice, the existing code of practice states that the focus should be on the reported wrongdoing and not on the person making the disclosure. So in that sense, the focus remains the same. It's on the wrongdoing. Persons concerned do have rights, you know, as it stands. So I don't see how, you know, the situation isn't going to change. It's just that it's more clear, and the persons concerned, I suppose the big change is that their identity must now also be protected, whereas that wasn't in the Protected Disclosures Act to begin with. So I hope that answers the question.
Great, thanks for that clarity or that clarification, Lorraine. So the next question relates to prescribed persons, and this is around the new requirements. As Lauren outlined there is a raft of new requirements on prescribed persons around, you know, informing the public of their role and providing information around how to make a disclosure. So the question here is regarding the website information that has to be provided. The heads of bill states that the remedies and procedures for protection against retaliation and the availability of confidential advice for persons contemplating making a protected disclosure must be provided. Is there a requirement here for prescribed persons to provide confidential advice? And I think that's the first question. And then the second one is, you know, regarding information on protection against retaliation by an employer may suggest that the prescribed person can actually protect the worker, which, you know, may not be possible. So Lauren, I might come to you on that particular question, or those questions.
So the First part is regards the confidential. Is your requirement to provide confidential advice? No. Secondly is regard protection from retaliation. There are ways within which that protection can be provided, such as of course protecting their identity, which would reduce the risk of any retaliation. The heads of bill also provides in head 22 for measures of support. So there is potential for the minister or a third party to provide comprehensive and independent information. And what's required of prescribed persons under head 22.2 is that they provide effective assistance to any relevant authority involved in the protection of persons from retaliation. So that really covers the role, I suppose, of prescribed persons in respect of the extent of protection from retaliation. But as regards the provision of the confidential information, the information on the website has to be about where those measures of support can be obtained.
Okay, and of course, as many of you know, Transparency International Ireland runs a national helpline, the Speak Up helpline, which does provide an independent, confidential source of information and advice to anybody who is considering making a protected disclosure or who may already have made a protected disclosure and wishes to seek further information. And certain callers who require legal advice can then, where appropriate, be referred on to the Transparency Legal Advice Centre. And we've heard from Lorraine, the managing solicitor of that centre this morning. So if you would like to find out more information about the helpline, you can visit our website, speakup.ie. I'm moving on then to the next question from Peter Whelan. How much detail is to be provided in communicating the final outcome in the case of external protected disclosures? This may lead the discloser to take their own court proceedings and thereby involve the protected disclosure investigators in private actions.
Any requirements on them I doubt very much whether we legislate for the amount of information or detail that has to be shared with the discloser on the outcome of the case. I would imagine that it'll be left. I mean, I would imagine there will be some guidance on this from the department anyway, but it will be to the effect that as much that the disclosure should receive as much information as is required without prejudicing the rights of the respondent in those cases, because obviously those rights will still be will still be unaffected. Their constitutional rights that respondent will have to continue to enjoy.
Okay.
But I mean, my point here would be that they should be sharing as much information as possible to show the discloser or to satisfy them that they've taken whatever action was necessary in that case, and in particular that they've learned from the disclosure, even if it's determined that no wrongdoing took place, that they're taking action to see the risk of wrongdoing addressed. Without prejudice to any investigation that's taken place. The information that's shared should be seen as valuable in its own right, without having to be determined as a protected disclosure. And Kate, Kenny, and Wim Franikova produced an excellent report on this for the ACCA, the Association of Certified Chartered Accountants, on whistleblowing procedures. And it makes a similar point that the information, irrespective of whether it is PD, should be considered valuable by the employer in helping address risk and highlighting red flags.
Okay, thank you, John. So I'm going to move on then to the final question, the Q&A from Hugh Wilkins, which relates to essentially the strength of protections for whistleblowers after transposition. And actually, he refers to the UK legislation here, the UK Protected Disclosures legislation, or whistleblowing legislation, PDA. So he says the context for this question is that protection under the UK PDA regulations means that whistleblowers who believe they have suffered detriment simply have a right to make a claim against their employers, or typically by then their former employers, through the employment tribunal. Even if they win and are found to be unfairly dismissed, remedy in practice is usually restricted to a financial award, usually paltry. The other theoretical remedies, re-engagement or reinstatement, are very rarely ordered. The outcome is that the whistleblower has lost their career. Does Ireland do any better?
No. I might take that, Stephanie. So in Ireland currently, well, having looked at 6 years of case law under the Protected Disclosures Act, there were only 12% cases that were successful, so only 19 cases. And there were just the remedies are essentially compensation. But unlike the UK, where there's no cap on the amount of compensation that can be awarded by the employment tribunal, in Ireland there is a cap on 5 years gross remuneration. So the largest award that was made for unfair dismissal was 2 years gross salary, which was just over €52,000. So it is the fact that we're going to see interim relief remedies brought in for penalisation claims. That's obviously a further strength to the Act, but that shouldn't just apply only to penalisation. It should be available also to detriment. And further, the cap on compensation for those who aren't in receipt of remuneration at €13,000 remains to be seen where that figure was ascertained, and if anybody does have any insight on that, I would welcome any advice on that. But what we need to see are really the remedies need to be just and equitable, and arguably, how is a cap on compensation ever just and equitable? What I might just at this point, I see there was a further question that came in on the Q&A as regards board members, and just to clarify, yes, non-executive members are now afforded protection for having made a protected disclosure under the Act. Further, in respect of, there was a question, sorry, I'm just going to take the opportunity to address these here.
Thank you. Yes, please do.
So just in respect of the test for reasonable belief, there's no indication that will change as regards whether or not a disclosure is a protected disclosure or not. The worker has to have a reasonable belief that the information they're disclosing tends to show one more relevant wrongdoings. That's the current test, and there doesn't appear to be any changes on that. Further, the test for penalisation that was established by the Workplace Relations Commission is if there is more than one causal reason for the penalisation, the question is, but for having made the protected disclosure, would the employee have suffered the penalisation? And the question is whether that could be retained, and arguably there's no indication that that's not going to be retained, except it's important to note that the EU directive does propose for a shifting of the burden of proof in such claims to the employer. So currently, under penalisation claims, the employee would have to show why they were penalised. There is proposal for that to be reversed. However, that hasn't been included in the heads of bill, but it is anticipated that that will be reflected in further drafts of the legislation.
Can I just add here as well, and I meant to mention earlier on, that the term worker may also want to be considered, some consideration might want to also be lent to defining workers in a way that extends the right to contractors as well to seek remedies through the Workplace Relations Commission, and also that civil protections be available to workers who wouldn't traditionally be considered workers, including members of the judiciary, members of the Oireachtas and local authorities. We're seeing case law emerge in the UK, which has extended the definition of worker, either you can correct me if I'm wrong, to members of the judiciary and I see no reason why members of the Oireachtas or members of local authorities as well could not make a protected disclosure and avail of the protections currently available under sections 13, 14 and 15, as well as 16 around confidentiality.
Okay, so I'm conscious that Marie or Mary, I'm not quite sure how to pronounce that name. Mary, you had your hand up to ask a question in person, and I've actually joined you to the panel now. If you'd like to unmute yourself, you could ask that question. Marie? Perhaps she has stepped away. Okay, well, let's just maybe come back to that in a moment. So just then a couple of other, I suppose, kind of more technical type questions. There's a question around whether the interaction, can you comment also on the interaction of the new bill with the wide range of extant sector-specific whistleblower legislation? Would anybody like to comment on that?
Well, I could make an observation that as things currently stand, cases do come before the WRC where there is clear confusion as to how the Protected Disclosures Act and the sectoral legislation interact. And the general result of the cases is that, you know, an applicant might think that they can choose either the sectoral legislation or the Protected Disclosures Act, but when the case comes on, if they brought it under the sectoral legislation, that's it. So I just think, you know, and some of these people have been represented, so I feel there's a need for a bit more clarity around how the Act and sectoral legislation will intersect. And then I don't know whether the questioner might also be thinking there's certain sector specific legislation referred to in the directive that they're contained in one of the annexes, and that's where you'd find them. But in relation to those, it's mostly the financial services sector, that those sectors specific rules will apply to those sectors. So there is an exclusion there. So,
okay, thank you. Thanks a million, Lorraine. One other quick question, as definition of worker has changed, does the bill clarify if an employee of a private service can disclose to the minister?
I mean, they currently can make disclosures to the minister. So what's necessary for a disclosure to a minister from a worker who's not a public sector worker, and the minister doesn't have a function, obviously, over their organisation if they're not a public sector body, they currently can avail of protections under the Act making a disclosure to a minister. However, the disclosure attracts a range of additional conditions for it to be protected. So it falls into that category of a wider public disclosure under Section 10 of the Act. So it is arguable that it will fall under the new, is it Head 12 for disclosures to a minister. So it'll have the criteria that John had mentioned in his presentation. And also there was just a question there as regards the person concerned, who was that? And yes, it is the person who would be the alleged wrongdoer in the disclosure. So that's the person that Lorraine had been speaking about.
Thanks very much, Lauren. So I'm going to turn now, I'm conscious of time, so we might finish up actually with this question, maybe just one more. So this is a question from Shane Kavanagh, again in the chat function or the chat button. So he has a couple of questions here. Will this legislation put a structure in place to allow for timely dispute resolution in compliance with the 1975 European Court of Human Rights? That's the first question. And the second question, does the panel think that Ireland, which is committed to align with the new directive on whistleblowing, should use its position as a member of the UN Security Council and its unique position taking up the presidency of the UNSC in September, to leverage the UN to address endemic global corruption by strengthening its commitment to protect and obtain redress for UN whistleblowers and those of its member states. So I might just actually start with the second question first of all, and Ida, I think you had a response to that particular question.
Yeah, so I put in the chat a very brief answer that, you know, whistleblowing protection at intergovernmental level, UN agencies, is a problem. It's known to be a problem by whistleblowing protection advocates and policymakers, and there have been formal recommendations to reform those procedures. I had referenced the report from 2015 of the UN Special Rapporteur on freedom of expression rights under the UN Charter, which said that due to the lack of external independent justice systems at the UN level, intergovernmental bodies essentially should follow the same best practice principles for a whistleblowing protection framework as nation states. I think I put a link to that report in the chat. In terms of what Ireland should do as a member state of the UN, I mean, I would just say any action towards improving those systems is going to be worth considering, because there is a global impact of whistleblowers not being able to speak up because of fear of not being properly protected at that level.
Thank you very much. And so then just coming to the first question there, will this legislation put a structure in place to allow for a timely dispute resolution in compliance with the 1975 European Court of Human Rights? I don't know if anybody, Lauren, would you have any comments on that particular?
No. Sorry, I don't know, maybe Lorraine.
Not to put you on the spot. Yeah.
Yeah, the only comment that I would make is that it's not really a dispute, it's an investigation into wrongdoing. You know, if disputes arise, there is currently a framework at the WRC, a mediation framework that employers and their workers can agree to attend. So there is an existing framework that could be used, but I think in relation to disclosures, we're talking about, you know, someone has disclosed wrongdoing and that needs to be followed up on. So that'll be my take on that.
Thank you, Lorraine. Just another quick question. Is the test for reasonable belief maintained, and is in place for reporting to the employer via other means than the new reporting channels, for example, to line manager? I think we have probably covered the second part of that, and the test for reasonable belief is maintained.
Yeah, I addressed that a couple of minutes ago.
Yeah. Okay, perfect. So we've addressed all of those. So I'm just checking through. Thank you so much to all of you for your very positive feedback on the session. I'm just having a quick look at the Q&A. Yeah, there was just a question around reporting persons by civil society organisations. Actually, had a question on this myself. So in relation to charities and civil society organisations, are they covered under the general scheme? Where are they covered as a public sector body, private sector body? How does that actually work?
I think that's going to have to be, you're going to have to look back to the definition of a public body in order to determine whether or not, you know, you're captured by that. It's a bit complicated and technical, but there's definitions, one in the Protected Disclosures Act of what a public body is, and then there is government resources available also that you can get online, that you can look at what makes something a public body that might fall under that. So that'd be the only guidance that I could offer on that question. Yeah.
Okay, thanks a million. There are lots of other questions coming in. Kate, I'm just wondering whether we will just maybe take just one final comment from Kate Kenny here, and then I think we will need to to probably wrap up the session. I'm conscious of, keeping people when obviously it's a busy morning for everyone concerned. But Kate Kenny has put a comment and a question in the chat button here, just talking about the actual implementation. Kate says there's a significant ask for prescribed persons and the new Protected Disclosures Office and organisations to fulfil all the obligations required. There's a concern. The concern is if there are no penalties for non-compliance, resource constraints might mean partial or limited implementation in practice. And Kate's question is if we should focus on more depth on penalties. So would anyone take that final comment there?
Yeah, I completely agree with Kate. Currently, the legislation, the Heads of Bill, does propose for penalties to be included, but is yet to specify what they are going to be. And having surveyed prescribed persons back in 2018, 83% said that they hadn't received any additional funding to assist them in their role, and 17% said they didn't know. And the requirement under the directive is that competent authorities, i.e. prescribed persons, are adequately resourced. And so that's the first part. We need to ensure that they're resourced both as regards the financial resourcing and also as regards staff. And in respect of training, and we know that there will have to be, particularly in external disclosure channels, so the prescribed person, there has to be a trained person. And something that arose from that survey as well was that when all prescribed persons were asked for additional comments as regard their role, they all said that they needed more regular training. Now, they had received some training, but for those who felt that they were not receiving disclosures on a daily basis, that they were kind of forgetting what was best practice for dealing with the disclosure. So we need to ensure that not only is there training, but regular training. Now, as regards penalties, the problem currently with regards to the public sector, who have to have these protected disclosures procedures in place, is that failure to have such procedures, that there's no accountability. And even looking at the cases before the Workplace Relations Commission, particularly in respect to public bodies, if there was no procedure or policy in place for the employee to use, that hasn't been factored into decisions but made by the adjudication officer. So there needs to be some sort of remedy or recourse for failure to have such a policy in place. Now, there are proposals for penalties for breaching the identity of the worker, and we see this in other jurisdictions. So, for example, in France under Sapin-2, there's monetary penalties for failing to protect the identity of the worker. So we are going to, there is proposals there in the Heads of Bill for penalties to be introduced, but it remains to be seen what the scope of those penalties are, and it's something to keep an eye on.
Absolutely. Thanks a million, Lauren. Just speaking about resources and training, so actually Deirdre has asked a question there, if any extra resources would be allocated to Transparency International Ireland to address the probable increase in protected disclosures and the need for legal support from our law centre. Well, the answer is we certainly hope so. Deirdre, we envisage, we've already seen a 44% increase in calls to our helpline last year. Obviously, many calls connect to the impact of the COVID-19 pandemic and health and safety concerns, but notwithstanding those particular calls, we are generally seeing an increase in calls to the helpline, which is wonderful in some ways because it shows that the word is getting out there. Through our Integrity at Work programme, through the work that we do, through webinars such as this, and through indeed your own word of mouth. But we certainly do need to scale up. We do need to scale up our staffing and our resourcing to be able to deal with what we envisage might be at least a doubling or indeed tripling of calls over the coming years. And we base this on the fact that we saw a 115% increase in calls to the helpline after the protected disclosures legislation came into effect in 2014. So I think I am going to wrap up the session right now. Thank you so much to all of our speakers, to Ida Nowers, to Dr. Lauren Kierans, to Lorraine Heffernan, and to John Devitt. I think it's shown that there is, first of all, a wealth of insights and information to be shared. There's also a huge interest in this area, and we've had very positive feedback from all of the people attending. I just want to apologise to anybody where we didn't get to your particular question, but we will actually take those questions and come back to you individually. It literally just is a case of running out of time. I'd also like to let you know that through the Integrity at Work programme, we are running a series of workshops this year for employers, for regulators, for government departments on the Protected Disclosures Act and the EU Whistleblowing Directive, and of course the changes that are being proposed in the heads of bill. And we have 2 workshops coming up in June on the 15th and 22nd of June. So I think my colleague Niamh is going to share with you all there in the chat function. Yes, she has indeed. Thanks a million, Niamh. So she's shared with you a link to our website where there is a list of all of those upcoming workshops. And also we will, as I said, be doing more events such as this event today. And we would invite you to follow us on our Twitter account or indeed on our LinkedIn account. The handles are there in the chat function, and any events that we have coming up will be publicised on Twitter and on LinkedIn. So I think it just reminds me to thank you all again, to wish you well, and we look forward to seeing you again very soon.
Just one last thing before everyone goes. We are speaking with the Finance Committee, the Oireachtas Finance Committee, this afternoon at 12:30 on this topic. We won't be they've asked us not to talk about the legislation itself, but we will be talking about the experience of whistleblowers and organisations and dealing with the Protected Disclosures Act. So that will be on the Oireachtas website live at 12:30. Thanks again, everyone.
Thank you.
Thanks.